It's now been well over a year since the activists arrested after the Bhima Koregaon violence were put in jail, apparently because they conspired to attack the Prime Minister or lead Naxal terror attacks. For 1 year, all of these activists, scholars, lawyers, teachers and others have been trying to get bail to no avail. So far, that's not worked out. No matter what the merits of the case, how has there been no decision on bail? The reason apparently has to do with the inability of the police to make copies of hard drives which contain electronic evidence that investigators have collected. For human rights activists, what is happening is a travesty of justice. That is our second focus on this program this evening. It's also pegged to an alleged remark by the Bombay High Court that said it had never questioned the respondents for possessing Tolstoy's work, War and Peace. There was a clarification from the High Court today. The reference which appeared in newspapers and elsewhere was apparently about another disturbing publication. So it wasn't as if the judge did not know about Tolstoy's work and apparently said that, but that's from another country. So there's been a denial to that on that. Joining us now for more on this, where this case actually stands, Suhas Chakma, the Director of Rights and Risks Analysis Group, Colin Gonzalez, the Supreme Court lawyer, Lalita Kumara Mangalam and Deshratan Nigam with us. Mr. Gonzalez, irrespective of whether the judge was referring to Leo Tolstoy's work or he was referring to something else, isn't it shocking that so many of these individuals are being questioned and locked up for what they read? What stops people from reading something, and how does one legally apply what one reads to one's activities? I don't understand that.
I don't understand it either, and I've seen so many cases where people are charged with having literature on their laptops. You can have anything on your laptop. It can be even, very, very sort of revolutionary material, so to speak, calling for, revolutions to happen and so on. You have material. That's all. Where is the criminality in this? Where is the crime? What section says you shouldn't read a book or see material which is, let's say, offensive to some and not offensive to others? It's a total misuse of the law, and I find it so shocking that there are so many cases in this country where people are taken in sedition cases. Can you imagine? Sedition means it's like waging war, taking up actions against the state, violent actions against the state. And what do you have? You have a poster, you have a book, you have an article, you have something somebody has sent you on the internet.
Yep.
It's totally a misuse of the law, and it must stop now. Yep. And I'm glad this Bombay High Court judgment has focused on this issue, because it must stop. You can have anything on your computer. Yeah. You can have anything, and it's not a crime.
Deshratan Nigam, what's wrong with books and what one reads? How does one draw a link between what these individuals were allegedly doing and what they read?
See,
if somebody reads Mein Kampf, it doesn't make them a fascist.
No, let us be very clear. Mere possession of a book or reading of a book is not a crime if it is not
and
banned.
Yet this keeps coming up over and over again.
Let me tell you, Supreme Court, while when it reserved the judgment on 20th of I think it was 20th of September 2018.
Yes.
It clearly said that they are going to look at whatever the evidence is there with a hawk's eye. And after examining the material on record, they denied them bail, did not interfere with them arrest, and did not even constitute an SIT, which was the demand of the accused. And then the matter has been sent. Now, as I said, mere possession is not, but they have been accused of a crime, and that aspect has been taken into consideration. And when a crime, any trial lawyer would tell you, there is a motive to a crime. Where do they get the motivation from? The link has to be established. Mere possession or reading is not a crime. I am again reiterating.
Yes.
But a link has to be established, the motivation, because they have been accused of having links with CPI Maoist, which is a banned organization, and the other crimes which they have been accused of. So it is not merely possession.
Okay.
Therefore, it is very important. They are trying to establish a motive, and that is what is being considered. Any trial lawyer will be able to explain this to you, and this is the stage of a bail,
right.
not an establishment of anybody's guilt.
So, Suhas Chakma, the word Deshrata Nigam mentioned was bail. Is it not perturbing that in 1 year plus, in fact, not 1 year, 5 of the individuals of the 8 have not been granted bail, and the others a few months less? Why should people be rejected bail or granted bail? Why should a decision to this end take so long? Why?
Well, when it comes to the question of granting bail, the critical issues are whether they are going to flee, whether they are interfering with the, with the evidence, or whether they are going to intimidate witnesses. None of these factors actually exist in this case. And further, actually, with respect to these 4 individuals, at least, charge sheet and the supplementary charge sheets have been filed. So, once the charge sheet have been filed, basically there is nothing else for the police to produce. You are not going to interrogate them in the judicial custody. So, if the police have anything else for questioning, they still have to take permission of the court. So, whether you take the permission of the court for interrogation in judicial custody or after releasing them on bail, it makes no difference. If you look at it, I think the only reason which the police had said is the fact that they have to copy, or they could not make copies of the hard disk could not be examined by the forensic expert, but they are already in the possession of the police. So, how are these individuals going to interfere in any manner with the evidence which are already in the custody of the police? So, I think the denial of the bail after so many months and years, it's actually a miscarriage of justice. If you look at it, the case, the charge sheet which has been filed by the police say that they are waging war against the state. They are promoting the ideology of the left, the Communist Party, the Maoist. They are creating caste conflict, disaffection in the society, and finally, of course, hatred in the society. Disaffection, caste conflict, hatred in the society, there are so many actors in this country which are doing it. Now, if you come back to the issue of propagating the Maoist ideology, you have BICO, who had been from the beginning openly supporting the LTTE, which is a banned organization, and the Supreme Court was very clear that it doesn't constitute a terrorist offense so long there is no involvement in the violence. So, you cannot, the law is settled, and I think it's the time, the police or the court should take immediate actions or decisions on the bail applications.
Before I go back to Deshrata Nigam and Lalita Kumara Mangalam, Mr. Gonzalez, another unbelievable part of this particular case is that all of the individuals under arrest have demanded that they be given a copy of the electronic evidence which has been collected against them. Now, apparently this is in 23 hard disks, and therefore, it is going to actually copying all of these hard disks and giving it to everybody involved means making 230 copies. In 2019, why is it difficult to copy a hard drive? And it's been 1 year. Why is this? What does this indicate to you?
Well, I don't know, but the High Court has evolved some very intricate way, or the trial court has involved some very intricate way of transferring that data in the presence of the accused persons and their lawyers. But the fact is that this is the kind of material you should have had ready before you arrested them. The copies had to be given to the accused persons long back. Today, you're wasting a year in court at the expense of the accused persons who are just hanging around waiting for you to transfer the information to the copies. So, it's a totally wrong thing to do.
Lalita Kumaramangalam, some reports have suggested that apparently to make each copy takes up to 7 hours. Now, which computer they are using, it's bizarre. And therefore, to make copies of all of these 23 hard disks is a process that will apparently take months. Does this not appear to you to be an effort at stalling the progress in this trial? This is a police argument which has been made.
Vishnu, I am not an IT expert, so I can't comment on the number of hours it takes to copy such disks. But up to an extent, I am willing to agree that yes, it shouldn't be that difficult either. But what the real reason behind the police either as you put it, procrastinating, and not wanting to actually see that these people get bail is, I don't think we really know it. And as has been pointed out by Mr. Nigam, this is not just about reading books or having literature in your hand, etc. But the police actually have given in their charge sheets the reasons why these people were picked up and put in jail to begin with. And
but there was no annexure which was given, ma'am, of the evidence that they had collected.
Fairly strong.
And neither was there any electronic evidence which was given to the accused. It's a charge sheet which is 7,500 pages long, but there were no annexures of the evidence that they collected and nothing handed over to people to defend themselves. And it's been 1 year since they're behind bars.
Look, the police has its own ways of working and its own reasons, I think, in this case. I'm not
sure they
extremely familiar with it, but I do know that, yeah, they do. Well, I mean, whether you laugh at it or not, they do. Now, I think we need to allow the police to do their work, and if the court finally decides to give these people bail, the decision of the court, of course, will be upheld. It's not as if the court itself has asked a few questions today where there were some misstatements, etc. Let's not make that into a big issue here. But the fact does remain that if the court decides finally to give bail to these people, the accused, I'm sure it will. And
no, ma'am,
this is not not that I'm trying
I
to
think the
justify
only
by
point
saying
one
this,
is making is
but
not saying that they should or they should not get bail. That a court decides. It's this slow death by process. That's what one of the relatives actually had to say. Why must a process be so long that it takes a year?
See, let me tell you, the matter is before the court. To grant a bail or not to grant a bail, it is a discretion of the court.
I'm not looking at it on the merits. I'm just saying why is the process so long?
I'm only saying, even presuming that Mr. Gonsalves is right for the moment, that the procrastination is taking place on the part of the investigative agency or the prosecution, then the court should have immediately granted them bail. But despite this evidence not being there before Supreme Court, you are talking about 24 discs, Supreme Court, whatever the material was on record, did not interfere with the arrest at that point of time. Now 24 discs, I remember at that point of time it was thought, and there was a statement that it was scripted and it was difficult for them to retrieve the information. That was the statement at that point of time.
How long ago was that?
See, whatever be the time, maybe they have not been able to break the code or whatever it is, I don't know, but it has to be expedited. But the fact remains, it is not in the hands of prosecution or investigation, it is in the hands of the court.
Yes.
And there are well settled principles. If a person is in judicial custody now, then the issues of tampering with witnesses or influencing them or tampering with the evidence become very, very important.
They just want a copy of the evidence. That's their right.
No, if and it should be provided. Right. It is a matter of right.
It's still not been provided.
It is a matter of right.
There in the original
and the hearing for the bail.
Mr. Gonzalez, you had a point.
No, the hearing is still going on. It's not as if it is concluded.
Yes, I want to put it in a larger. I want to put it in a larger context. This Bhima Koregaon case will go down in history as the second ADM Jabalpur case. It is actually the turning point in the new emergency that is emerging. The Supreme Court majority judgment was wrong, and it did grave disservice to these persons who are some of the finest lawyers for the poor in this country. They are real karma yogis, worked all their lives for the poor. And if you look at the charge sheets, talking about waging war, did they throw a bomb? Did they fire at anybody? Is there an overt act? And you look at the evidence, it was so slender. Some kind of letter written without a signature and so on and so forth. If this case was heard in the 60s, where criminal law standards were little pure, this case would have been junked at the inception. But now judges are not ready. Judges are not ready to understand the political situation in which we are in, where you have a political bully who's taking some of the finest people from society and putting them in jail and making up stories about them. The minority judgment is for the three judgments. The minority judgment you only have to read, and it's such a beautifully written judgment, and it distrusts the police for what they are doing, and it says we must have an independent SIT. That was all that needed to be done, not keep this investigation in the hands of these police who are making up these tales about people. No evidence against them at all. And let me say one thing, the intention is not to convict, because they cannot convict. The intention is to cause prejudice, tell lies to the court, etc., and ultimately drag it on and on. The intention is to keep them in jail as long as possible, because the end result will be acquittal, and that is the nature of this case.
Okay.
See, I'll tell you, I am not the one who will prejudge the entire issue. It is sub judice, it's a matter of trial, everything is to be proved there in a court of law. And Mr. Gonsalves can have that luxury, to prejudge and hold them innocent. And the fact remains, let's wait the judicial process. Yes, you have a right to criticize Supreme Court judgment, fine, it's all right. But Supreme Court is wisdom, and probably for the first time, Supreme Court is looking things in a very different manner. Things which used to go scot-free earlier is not being allowed to go scot-free, and things are being taken very seriously. That's the other side of the view. So I mean, it cuts both ways, and let's wait for a judicial process to be over.
Chakma, go ahead. We need to wrap this up. Yes, go ahead, Mr. Chakma.
No, I just wanted to point out one thing. What Mr. Desnatam Nigam is referring to the Supreme Court judgment, it was a year back. And since then, the police has conducted the investigation. All the evidence is in the possession of the police, and the police have produced them before the court. Now, you do not require these persons to be detained for interrogations. Since you have collected all the evidence, why are you holding on? Of course, it's for the judge to decide whether to give bail or not.
That is where the issue of tampering with the evidence and witness comes.
Obviously, it makes it difficult for the...
Where does the issue of tampering with
evidence tampering of evidence will
already
come...
exists with the police. See, it's just a question of giving it to people to defend themselves.
What I am saying,
they are already in the possession of the police.
I am saying witnesses. Witnesses are part of your evidentiary process.
Yes,
and therefore the possibility of those witnesses who would be there.
But the evidence itself is electronic.
No, it may be.
But there may be other evidence.
Have you seen the list of the witnesses?
No, let us take the holistic
Have you
view.
seen the list of the witnesses?
No, let us be. No, I am saying I am making a general proposition.
No, why holistic view? Have you
nor you have seen.
But what is the list of witnesses? Tell us, Mr. Chakma, what is the list of witnesses?
He wouldn't know, I am sure.
Mr. Chakma, can you hear me? What is the list of witnesses that you are referring to? Yes,
Mr. Nigam.
I am making general proposition.
There are no list of witnesses except the police. It's not a question of general proposition. It's a question of somebody's right or somebody's liberty being infringed. So you have to be very specific. The specific point here is the list of witnesses are only the police witnesses. There are no Maoists who have been listed as witnesses except possibly Ganapati.
I don't
now are you
think
going
so.
to
That's a
fine
correct
him
proposition.
and detain this person still?
That's not a correct proposition you're making.
See, the proposition is all the evidence is in the...
Do you know who...
No, all the evidence is in the possession of the police.
Witnesses.
A person, if is in judicial custody, the point of tampering with evidence is influencing the witnesses becomes very important, because they have been taken away from the police custody and given to judicial custody.
No,
so
it doesn't become important.
So those issues become very important.
If you have already collected the evidence, see, when do you file a charge sheet?
Then please tell me what is the purpose of judicial custody then?
After examining all the evidence.
People can turn hostile, Mr. Chakma.
What is the purpose of judicial custody once everything is collected?
Well, I think one way or the other, I think we can all agree that it's taken more than a year to be at this stage where apparently the case is not even being heard with a great deal of frequency. So irrespective of what you believe the facts of the case are, where is the process of justice? I think we can't sit here and judge or decide or anything. A court is supposed to do that. But is this the way our judiciary is supposed to work? I think that's where we're asking questions tonight. I'd like you very much, thank you all very much for joining us